$50,000. That was the fine sitting in Marcus Webb's mailbox on a Tuesday morning. Not for a crime, not for destroying property, not for harming a single soul. It was for grass. 1 inch of grass. And that was the single biggest mistake this HOA ever made. Marcus Webb had lived on Birchwood Drive for 11 years. 11 years of maintaining his property with pride, paying every bill on time, and keeping largely to himself in the kind of quiet, suburban way that should have made him invisible to anyone looking for trouble. His lawn was never the showpiece of the neighborhood. He wasn't trying to win any awards, but it was clean, it was cared for, and by every reasonable standard a reasonable person might apply, it was perfectly fine. The Birchwood Heights Homeowners Association, however, had made it abundantly clear over the years that they did not consider themselves reasonable people. They considered themselves the law. The association had been running the neighborhood since the late 1990s, founded by a small group of original developers who had embedded a dense thicket of rules, regulations, and fee structures into the deed covenants of every home in the community. On paper, the HOA existed to maintain community standards, manage shared green spaces, and protect property values. In practice, it had evolved into something closer to a neighborhood surveillance operation, led by a board of 5 volunteers who had held their seats for over a decade without a single contested election. The board president was a retired civil engineer named Gerald Fitch, a man who approached HOA governance with the energy of someone who had always wanted a little more authority than life had given him. Gerald had a habit of walking the neighborhood on Saturday mornings with a clipboard and a measuring tape, and the residents of Birchwood Heights had long since accepted this as one of those unavoidable suburban realities. Marcus had always managed to stay off Gerald's radar, until the summer that everything changed. It had been an unusually brutal July. Temperatures across the region had climbed into the high 90s for 3 consecutive weeks, and Marcus, who worked long hours as a logistics coordinator for a regional freight company, had simply fallen behind on his lawn maintenance. Not dramatically behind. The grass hadn't turned into a meadow. There were no weeds spilling into the sidewalk, no overgrown hedges swallowing the mailbox. The lawn was just slightly longer than usual. By Marcus's own estimation, maybe an inch or so beyond what was typical. By Gerald Fitch's measurement, it was 4.3 inches. The HOA covenant stipulated a maximum of 3.5 inches. The difference between those two numbers, less than 1 inch of Kentucky bluegrass on a dry summer afternoon, would become the opening chapter of a legal battle that would eventually reach federal court. The first notice arrived on a Wednesday. It was a standard violation letter, the kind of form document that the HOA had clearly printed in bulk, with a blank line for the specific infraction and a checkbox for the relevant covenant section. Marcus read it twice, shook his head, and went out that weekend to mow the lawn. He assumed that would be the end of it. It wasn't. 3 days after he mowed, a second notice appeared. This one informed him that because the initial violation had not been resolved within the specified correction window, a window Marcus had apparently missed by 2 days, he was now subject to an additional fine. The original fine had been $150. The second notice added another $250. Marcus called the HOA's management office and explained the situation calmly. He had mowed the lawn. The grass was well within the required height. He had simply missed the correction deadline by a narrow margin due to a work schedule that left him little flexibility. He asked, politely, if the second fine could be waived given the circumstances. The property manager he spoke with expressed sympathy and told him she would pass the request along to the board. The board denied it. Over the following 6 weeks, Marcus made 3 more phone calls, sent 2 written requests for reconsideration, and even attended a monthly HOA meeting in person to address the board directly. At that meeting, Gerald Fitch listened to Marcus's explanation with the expression of a man performing patience rather than actually feeling it, and then informed him that the board had a duty to apply the covenants consistently and without favoritism. The fines would stand. What Marcus did not know at that meeting, what he had no way of knowing, was that the fines had already been compounding. The HOA's covenant included a clause buried on page 47 of the original declaration document that allowed for daily compounding penalties on unresolved violations. The clause had been drafted in the late 1990s and had never, to most residents' knowledge, actually been invoked. Until now, Gerald Fitch had decided, apparently, that Marcus Webb was going to be an example. By the time Marcus received the formal demand letter, a thick envelope with the return address of an HOA-affiliated collections attorney, the total outstanding balance had climbed to $52,400. Marcus sat at his kitchen table for a long time with that letter in his hands. He was not a man who scared easily. He had built a stable life through discipline and consistency, and he was not inclined to panic. But $52,000 was nearly his entire emergency fund. It was his daughter's first 2 years of college. It was the kind of number that could genuinely alter the course of a family's financial life. He read the demand letter again. Then he set it down, picked up his phone, and did something Gerald Fitch had likely never anticipated. He called a lawyer, not a general practice attorney, not a family friend who dabbled in real estate. He called a civil rights and property law firm that specialized in HOA disputes, a firm whose name he had found after 2 hours of targeted research that night. The attorney he reached was named Claire Vasquez. She asked him to send her the full violation history, every notice, every letter, every piece of correspondence, and a copy of the original HOA declaration and bylaws. Marcus sent everything he had, and then Claire Vasquez started reading. What she found in those documents would change everything. Claire Vasquez had been practicing property and HOA law for 14 years. She had seen predatory fine structures before. She had seen boards weaponize covenant language against homeowners they simply didn't like. She had seen compounding penalty clauses that were borderline extortion, and she had seen associations use the threat of liens and foreclosure to bully residents into paying amounts no court would ever rationally uphold. She thought she had seen most of what this particular area of law had to offer. Then she read the Birchwood Heights HOA documents, and she realized she had found something different. The first issue she identified was procedural. The HOA's own bylaws required that any fine exceeding $500 be approved by a full board vote at a properly noticed public meeting. Marcus's file contained no record of such a vote. The escalation from a routine grass violation to a 5-figure compounding penalty had apparently been authorized by Gerald Fitch alone, acting unilaterally, without the board convening, without minutes being recorded, and without any of the procedural safeguards the association's own governing documents required. That alone was enough to challenge the fine in state court. But Claire kept reading. The second issue was larger, significantly larger. The Birchwood Heights HOA had been incorporated as a nonprofit association in the state, which meant it was subject to specific statutory requirements around governance, record-keeping, elections, and financial transparency. Claire requested the association's public filings through the State Attorney General's office, annual reports, board election records, and financial disclosures that any registered nonprofit was legally required to maintain. What came back was illuminating. The HOA had filed its initial nonprofit registration in 1998 and had submitted annual reports for the first 4 years of its existence. After 2002, the filing stopped entirely. The association had never formally dissolved, but it had also never renewed its registration, never submitted updated officer information, and never filed the financial disclosures required under state nonprofit law. For over 2 decades, the Birchwood Heights HOA had been operating as an unregistered, legally non-compliant entity, collecting dues, issuing fines, placing liens on properties, and exercising authority over hundreds of homeowners without any valid legal standing to do so. The board had been governing a neighborhood as though they had legal authority. They didn't. Claire brought this information to Marcus in a meeting that lasted nearly 3 hours. She walked him through each finding methodically, explaining the implications in plain language and answering every question he had. By the end of the meeting, Marcus had 2 choices. He could accept a negotiated settlement, likely getting the fine reduced significantly or eliminated entirely, and move on. Or he could pursue full litigation, challenge the HOA's legal standing from the ground up, and potentially open the door to recovering damages not just for himself, but for every homeowner who had paid fines or dues to an entity that had no lawful right to collect them. Marcus chose to fight. The initial filing was made in state civil court, challenging both the specific fine imposed on Marcus and the procedural violations that had produced it. The HOA's attorney, a mid-level real estate lawyer named Dennis Holt, who had likely expected this to be a routine collections defense, filed a standard response and moved for summary judgment. arguing that the covenant language clearly authorized the penalties assessed. Claire had anticipated this. Her counter-motion introduced the nonprofit compliance issue, attaching the state filings, or rather, the conspicuous absence of them, as exhibits. She argued that an unregistered, non-compliant entity lacked the legal capacity to enforce contractual obligations against homeowners, and that every fine, lien, and dues collection undertaken by the HOA after its registration lapsed was potentially void. The state court judge did not grant summary judgment. Instead, she ordered a full evidentiary hearing and simultaneously referred the nonprofit compliance question to the state attorney general's office for review. That referral was the beginning of the end for the Birchwood Heights HOA. The attorney general's office launched a formal investigation. Investigators requested 22 years of financial records. They reviewed board meeting minutes, the ones that existed, which were incomplete and inconsistently maintained. They interviewed current and former board members. They pulled property records to identify every lien the HOA had placed on homes in the community since 2002. The investigation took 4 months. What it produced was a formal finding that the HOA had operated illegally for over 2 decades, had collected an estimated $1.2 million in dues and fines without lawful authority, and had placed liens on 11 properties, including 2 that had resulted in forced sales under circumstances the Attorney General's report described as deeply troubling. The federal dimension entered the picture when Claire, working with a co-counsel who specialized in fair housing law, identified a pattern in which the HOA's most aggressive enforcement actions had been disproportionately directed at minority homeowners. The compounding penalty clause, it turned out, had been invoked exactly 4 times in the association's history. Marcus was one of the 4. The other 3 were also people of color. The enforcement records, cross-referenced against the demographic profile of the neighborhood, produced a statistical pattern that Claire argued could not be explained by coincidence. The Fair Housing Act complaint was filed with the Department of Housing and Urban Development. Federal investigators opened their own inquiry. Gerald Fitch resigned from the board within a week of the federal filing becoming public. The other 4 board members followed within 10 days. Dennis Holt withdrew as the HOA's legal counsel shortly after. The state court case concluded with a judgment in Marcus's favor. All fines vacated, legal fees awarded, and a court order requiring the HOA to formally dissolve its operations and submit to a supervised accounting of all funds collected since 2002. The federal fair housing investigation resulted in a settlement that included compensation for the affected homeowners and a formal agreement ending the association's existence. On a Thursday morning in early spring, 18 months after a measuring tape found 4.3 inches of grass in his front yard, Marcus Webb stood on his lawn and watched a city crew remove the Birchwood Heights HOA sign from the entrance of the neighborhood. He hadn't planted the grass any differently. He hadn't changed a single thing about how he maintained his property. He had simply refused to be made an example of, and in doing so, had become something else entirely.